Thanks for joining us. Let's start this thing. Welcome to the In-Rem Podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody. Happy Tuesday. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like. Make sure to subscribe to our channel, whether that is YouTube, whether that is Facebook. That helps us provide content to you, content that you like, that's usable for you. But again, make sure to like and subscribe. Also, we want your feedback. We do want you to leave comments if you have questions, and if we have a moment during the show to answer those questions or pose those questions to our guests, we want to be able to do that. So engage with us, leave us a comment. We'd be happy to answer it if we can. And with that, we're going to go to Sean. If you would give us our legal update.
Well, thank you, Andy. So today I want to talk about opportunities for inherited properties. One of the common scenarios that we see here at our firm with our clients is situations where mom and dad pass away and they leave their assets to their children. Let's say in this case, 5 children. Hypothetically, there's 5 children, and they leave the real property or the house to all 5 children. So each child's going to receive a 20% interest in the property. We actually talked about this some last week, where the property goes to these 5, and 4 of the 5 want to sell the property and they want to liquidate it. And there's one sibling who was living in the property with mom and dad, continues to reside in the property, has no interest in moving out of the property, has no interest in paying rent, and they don't want to sell. They're the holdout. So what do you do in that scenario? There's a number of options, but one that I've found that can be useful and profitable, frankly, is to work with the 4 other siblings to purchase their interests in the property. So you would purchase each of their 20% interest in the property for an agreed upon price. They would then deed their interest to you, and you would be an 80% owner of the property, with the remaining sibling owning 20% of the interest. A lot of people think, well, how do I do that? Don't I have to buy the entire property? And the answer is no. That one owner can always convey their interest in the property to someone else. And then at that point, you own a percentage. So in this case, you would own 80% of the property. Well, in Arizona and outside of Arizona and other states, an owner of real estate does not have to maintain that property simply because another owner is not willing to sell. They can actually go into court and force the sale of the property. In Arizona, we call that a partition action. It's kind of an archaic term that came from the days when you could actually partition property. You could, draw a line down the middle and say, you receive the east half, you receive the west half. Well, when you have a single family residence on the property, you don't have that opportunity. You can't cut the residence in half, but we still call it a partition action. But what a partition action means is that the court will then receive the complaint. There's really no defense to the action, and the court will appoint a real estate agent in Arizona anyway, who is empowered to then sell the property. And if the sibling remaining in the property, that's the holdout, they refuse to cooperate or don't want to sell, the court can actually give the real estate agent, who is given the title once they're appointed as a special commissioner or special real estate commissioner, the court can actually give them the power to sign closing documents on behalf of the holdout sibling, so as to cause the property to be sold. And so the property is going to be sold at fair market value. When you purchase the four siblings' interests, a lot of times they're not looking to sell their interests at fair market value for a number of reasons. Number one, they don't want to file that lawsuit against their sibling. They have no interest in being in a lawsuit against their sibling, but they do want to liquidate their interest. They want to be out. And so because of that, and because they know that there's a lot of work to be done, even after they convey their interest and they liquidate their interest, they generally give a pretty deep discount on the purchase of their interest so that it's someone else's problem. They just don't want the headache. They don't want it to be their problem. But it's an investment opportunity for somebody who's willing to take the risk to move forward to, take that interest and then over a matter of time, push the issue forward and complete the sale of the property for fair market value.
And I think it's fair to say that though there might be errors where there might be errors where their feet are dug in and they don't want to sell the property. But once this gets sold, or 80% of the interest gets sold and they're left holding the bag, that it's really just a fait accompli. It's going to happen. And at that point, they either continue to dig their feet in the sand and litigate, or they settle. Either way, it looks like a good opportunity if the price is right for an investor, right?
You're spot on. So there really is no defense to a partition action. The only real issue in a partition action is the allocation of the closing proceeds. And what I mean by that is if the holdout sibling who's living in the property rent-free has been there for 6 months, the remaining siblings may have the ability, if they want to pursue it, or in this case, it would be the investor who owns an 80% interest. If they want to pursue it, they may have the ability to say, well, you've been living here for 6 months while we're litigating this partition action rent-free, so you have to pay us our share of the fair market rent out of your closing proceeds. And a lot of times that would be where the fight is, but otherwise there's no defense. So you're right. What happens is the lawsuit is filed, the complaint is served, and if the holdout sibling employs an attorney, most of the time the attorney is going to look at it and say, well, there is no defense. Why don't we try to receive the best price we can for the property and for your interest and obtain the most money for you, instead of spending a bunch of money on attorney's fees fighting and litigating this case, and then it results in a settlement. But a lot of times it requires more than, say, a demand letter. It actually requires the filing of the lawsuit and the service of the complaint.
Gotcha. All right, lesson for the day here. Just because if the real estate opportunity looks good enough, just because you can't get all the owners on board, there is a pathway. There's a pathway forward, and it may be a good one. You're just going to be factoring in the cost of fees going forward and what that might look like. One follow-up question: how does that, from an investor's perspective, how does attorney's fees factor into that with regard to a partition action? Because we know in contract actions, right, you have a prevailing party might have an option for an award of attorney's fees. How should a real estate investor price that in if they're thinking partition?
So unfortunately, with our partition statutes, there is no fee shifting. So you don't have the ability to shift fees. So the investor needs to factor that in as part of the amount that they're paying for the other siblings' interest, because they're going to have to pay attorney's fees, and they're not going to be able to recover those attorney's fees from the holdout sibling. And so they're going to be out those fees. But likewise, the holdout sibling is going to be out those fees as well. So if the holdout sibling hires an attorney, then the holdout sibling will be out their fees as well. So a lot of times they look at it and say, well, it's diminishing returns for me to hire an attorney and to fight this lawsuit, because at the end of the day, every dollar I spend on attorney's fees is less money in my pocket from the sale of the property. And the same with the investor. Every dollar that they spend on attorney's fees is less that they're going to receive from the sale of the property.
So the calculus really here is from an investor's perspective, is this to create the leverage. From the heirs perspective, it's diminishing returns. It's just going to cost me more to fight this. Let's just get a deal done. That's going to put more money in everybody's pocket.
Exactly.
All right, let's get into our topic for today. The title of the show, Best Contract Strategies to Seal Unique Deals. That was the point of our show today. That's what we wanted to focus on. For today, we have as our guest Rashell Jarvis, owner of Constant Close. She's going to be here. She's here with us to discuss best contract strategies to seal unique deals. Rashell, thanks so much for being with us.
Absolutely. Happy to be here with you guys.
Yeah, we're so happy to have you. You're the owner of Constant Close. How long have you been in the real estate industry?
I've been doing this a little over 16 years. So I've been, for a little bit. So it's been awesome. And the journey's been a little bit crazy as real estate is, but yeah, a little bit over 16 years.
Tell us about Contact Close, what Contact Close does and what you do with it.
Yeah, Constant Close is a national transacting kind of consulting business. Now, what does that mean, right? That's a long word, but basically, what we've done and the way that we've kind of breeded, or I've breeded this company, is seeing the value that it gives to investors. We all know that when we're taking down properties, the part that takes that time away is the transaction part. What you guys were just talking about in regards to, all of the different elements of it. This is where we come in and provide that value in all 50 states. So we have our attorney or our title partners in all 50 states, so we can navigate these issues and be able to handle it so the investor can focus on what they're good at, usually managing a team or getting their deals. So we're able to provide that value in all 50 states, whether it be wholesale or creative, based upon my knowledge in the industry and training my team. We give that value to investors nationwide.
What should investors be looking for as you help kind of facilitate this for them, given that a lot of these real estate transactions for investors can be unique? Maybe they're not the garden variety transaction.
Mhm.
What should they be looking for in terms of a title company or closing attorney? Is there something specific they should have on their mind in trying to decide who to use and how to move forward?
Absolutely. This is imperative to getting the transaction closed. So, what they need to be looking for is making sure that this attorney or this title company has the knowledge base to be able to be a good partner in their business. We have different partners as we navigate this transaction. So, the first thing that you should do is either hire an expert like myself, or either vet that title and attorney, go over your contract with them, let them see your contract, and make sure that they know how to navigate these pieces of the transaction. Wholesale is a little bit easier to find, but these creative sides is where it gets complex. So don't waste your time and just open it up with a local person. Make sure you vet them and ask them the questions. Have you done these deals? How do you handle it? Is there anything that I need to be aware of? So it's basically just vetting them like you would a partner and making sure that they can handle all of the elements of the transaction.
Got it.
Mhm.
So we want to go through. We know you deal with and are working with investors on a lot of unique types of deals. So we just want to go through some of those transactions that you run into, get an idea about the kind of unique transactions that Constant Close specifically handles. Uh, I'm going to start this off with a question, though maybe more than a question. You mentioned wholesale
Mhm.
transactions. What do you see in there? Do you handle wholesale transactions at Constant Close?
100%. Yes, we do.
What unique issues uh, do you have to deal with in Constant Close in kind of managing a wholesale transaction?
The wholesale transaction, easier to navigate, obviously, in regards to like the A to B and the B to C contract. But the thing that we help navigate and what we see is just basically being that person on top of the title company or the attorney to make sure that all of the different elements, for example, are being brought to the table. Because the truth of it is, you have a wholesale deal which you're buying it at a discount, right? 75 to 85% ARV. But that's not the end of the numbers. So what I know being an expert is, hey, we got to pull that preliminary title report abstract, depending upon what state that you're in, to make sure there's nothing in addition that we need to account for, right? So, and these are the things to know: what report are we pulling, and how can we help you make sure that you have your numbers? And if you don't have your numbers, that could really kill a transaction, right? Time is of the essence in these types of things. So this is what we see. A lot of new wholesalers or wholesalers in general are so focused on getting the deal, as they should be. But where we come in to help them is, let's make sure we have all of the numbers. I mean, we've seen things as funny as people trying to sell other people's houses, like knowing how to look at that title report, knowing how to navigate it and make sure we have everything. So I would say that would be the most common thing. And then also, I think our additional value is we don't just push paperwork around, which is really important, is we're able to see it from the investor hat and say, listen, you might have locked your deal up a different way. So when I say consultant, that's where we get in and we really go through the deal to say, do you have the right number? Your money and buyer didn't put the earnest money in within 48 hours. That's an issue. We need to start looking for another end buyer. So there's a lot of different things. So I would say the preliminary title report is something we really help them navigate in a wholesale deal, and then helping them to really understand the wholesale transaction if they're new to the industry.
Hi, Rashell. Thanks for being with us today.
Hey, Sean.
So do you also handle, or does Constant Close also handle novations?
Absolutely. Yeah, we're very heavy on the creative side.
Oh, excellent. And I'm assuming double escrow. If you handle novations, you're going to handle a double escrow.
Right.
So tell our listeners, some of them are experienced investors and then others are kind of, new in here. And a lot of times I'll bring up the idea of a novation to even more experienced investor and like, what's a novation?
Right.
So can you kind of, tell us, the difference between a traditional or standard wholesale transaction and a novation?
Absolutely. So, and thank you for letting me know that. That way I know who I'm speaking to. I'm like, I don't want to get into the weeds if people are like, what is she talking about? So, the wholesale transaction is basically where you're buying a property at a discount and you are going to assign your option with an end buyer. So you're going to have an A to B contract. So with the seller, and then you're going to have in your contract, as we know, Sean, it has to have the right to assign. So you're going to let your seller know that to be within the legalities of being able to assign it. And then you're going to assign it to an end buyer, which will be an assignment contract between yourself and your end buyer. So that's a wholesale deal. Like I said, buying at a discount. Now, a novation deal, what I have seen with doing these deals in all 50 states, people are using them for a lot of different reasons. I would say the most common novation contract that I come across is when you are doing a fix and flip in one escrow. So the power of novations is to be able to possibly, give the seller a little bit more money than you could if you bought it at a discount, for example. So if you have a novation contract, this is going to be a contract that you are looking to fix and flip and sell on the retail market. The power of the novation, like I said, is you can offer a little bit more to the seller, but also you can do everything in one escrow. That's when the legalities come out. So how do I do that? How do I sell a property? How do I fix and flip it if it's not my name? Well, that's where Sean, myself, or other people in the industry come in and assist you with making sure that you have the supplemental documentation. And this, I can't say how imperative this is to make sure that you do this. Why? Some sellers fall in love with their home after they see it rehabbed. Mm-hmm. Things change within 90 days. So you need to look at these transactions as that you need to protect yourself. But that's what a novation is. It's a fix and flip in one escrow where you lock down the contract with the seller. You do your rehab. Normally these are 90 to 120-day escrows. And then you're going to list it with the realtor on the retail market. And that retail buyer that comes in is going to fund the full transaction based upon the contracts that have been drawn up with the seller and the end buyer. I would say that's the most common type of novation, but I do see people do novations where there's no rehab. where you do the double close. I have a deal like that right now where they're wanting to novate the first transaction and be able to just have the double close and sell it on the retail market, following the same principles with the listing agent and then funding the transaction. So hopefully I did a good job of explaining that.
No, excellent. Although, and as attorneys, we struggle with this all the time. You use some legalese there, so I'm going to define a few of the terms that you said. So you use the term novate, and it's important for the listener to understand what the term novate means, which novate means replacement. And so, under your normal wholesale transaction, like you said, it goes A to B and then B to C.
Mhm.
And then C basically stands in B's shoes and closes on the original contract between A and B. The contract is as drawn up initially, nothing's changed. Versus in a novation, you have A to B, but then you have C that comes along, but C does not enter into an assignment with B. C actually enters into a new contract with A, which is the novation, right? The cancellation of the prior contract. So C enters into the contract with A, cancels B's contract, and that's where B gets paid, right? Because if I have a contract with somebody, I don't have to just cancel that contract willy-nilly. That's specific performance. If I enter into a contract with the seller and the seller refuses to sell, I have a right to go and enforce my contract.
Mhm.
So B has a right. So B says, well, okay, A, seller, you want to enter into contract directly with C. Well, wait a minute. I have a contract with you here, so I'm going to cancel it, but I want a fee for, my cancellation, if you will.
Yeah.
And so that's how, B ends up getting paid versus a traditional wholesale, right? You have an assignment fee. You have C paying B for the right to step into B's shoes and close on that original transaction.
Right.
What's the significance of the novation? You mentioned the idea that, oh, well, wait a minute. The seller or the property can sell for a little bit more than what maybe it would sell for in just your wholesale or assignment scenario. Why is that? What are the factors that come into play on that?
Right. So normally when you're taking down a fix and flip, we want to buy at as big as a discount as we can. Why? Because as our spread as investors, right, gets larger. So with these novation deals, the reason why is because they're selling it on the retail market through one escrow. So how we can beat out other wholesalers is saying, you know what, we educate our sellers about the deal, about the contracts, and we say instead of offering you 250, we're able to raise that price to an additional, let's say $10,000, $5,000, whatever it is, for you to hold on, allow us to do the escrow for 90 days. So we can offer a little bit more, obviously depending upon our numbers, because we know we're selling on the retail market. In a market like today, we know it's probably going to go over list price if we list it the right way, and we're probably going to make more. So it's the power of the novation to be able to help the seller or the investor not have to pay double closing costs with the right documentation, but also to be able to beat out other wholesalers and you can offer a little bit more.
So talk to me about what documents are required to successfully close on a novation.
Yes, this is my favorite part because I'm all about disclosure. So I'm like, please, when people come to me, don't just use a PSA. So there's quite a few. So let's chat about that. So obviously you have your purchase and sell agreement. I get a lot of documentation where people use their own document, their own PSA, whatever that looks like in whatever state. But the documents that you need is an actual novation contract. That novation contract is going to explicitly tell the seller, yes, you are in contract with me, but there is going to be, like you said, a cancellation, and we are going to find a retail buyer. On the contract, it'll actually say TBD because we don't know who the retail buyer, but the contract does emphasize and does a good job of explaining to the seller once you read it. I play devil's advocate all the time to say, if this is in front of a judge, does it explicitly say and does it articulate the facts of the seller is aware that there's going to be another buyer in here, and they are going to come and you're locked down at this price and all of the different things for the transaction. So you need a novation contract for sure to let them know. One of the other things that's very implemental to the investor is your money needs to be secured, right? So let's say you have a rehab budget of $40,000 to $80,000. And fortunately, I've seen this in so many different scenarios where I've recommended this and the investor decided not to do it. Cringe. It was really hard, but you need to file some type of memorandum if you're in a different state of UCC, whatever that looks like, to protect those funds. So, and that is also the disclosure that you have with your novation contract that the seller will sign, that I do understand that a memorandum will be filed. And as we articulate them to that seller, this is the reason why. Unfortunately, we've seen these scenarios happen. So I'm letting you know every step of the process. So you would definitely need a novation contract. You would need a memorandum that would get signed by the seller with them being aware that it's going to be filed. And then you would need some type of power of attorney. And now, why would you need a power of attorney? Now, this would not be a power of attorney for the seller. It would need to also explicitly state that this power of attorney is for the rehab, to pick the listing agent and to handle the offer that's picked on the retail market. And that's really important that you hire an attorney or you get a hold of documents that state that, because power of attorneys can make a seller feel sometimes uneasy, right? Especially, and you know the reasons, so many reasons as to why. So make sure you get the right type of power attorney and that you can explain to them, it states here that I will act in your best interest, that I will act, as your agent, you being the principal of the home, and this is what the power of attorney is for. So I would say those would be the three things that you would absolutely need. At constant close, we have an acknowledgement of the power of attorney and a notice of the power of attorney that the buyer and the seller will sign. But those would be the three things that I think are implemental to having a successful novation transaction.
There's a lot of documentation for a novation, and you provide. So if somebody hires Constant Close and they say, okay, I'm new to this novation thing, I want to do a novation, and they come to you, you will assist them with the forms and whatever else they need to pull it off.
Absolutely. And learn how to do it the right way. That's what I always preach, and that way you can see how all of these pieces come together. But yeah, they can definitely hire us for that.
Rashell, let's talk about double escrows. Does Constant Close assist with double escrows?
Yep.
From a document perspective, what does that look like?
Yeah. Double escrows, as we were talking, like, let's say, very common in wholesale deals, right? So it's going to look a little bit different. A scenario where people will use double escrows is sometimes we have some wholesalers that have a big spread on their wholesale assignment, right? We're talking $80,000, $90,000. We all know that can make the seller feel a little bit, a little bit weird sometimes that they're getting that spread. So what does the documentation look like? Your A to B, you have a contract with the seller, and just a regular PSA. It's going to actually close. The next escrow is going to close within 24 to 72 hours, and it's going to be another purchase contract. So since you close on the first A to B contract, if I am the wholesaler, I will be the seller on the B to C contract. So we'll have another PSA that will be drafted from me and my end buyer. So it'll be two PSA documents, and then closing with the seller on the first transaction, and then closing with the new buyer on the second transaction.
So not quite as document heavy as the novation.
Right. Yep. A lot easier.
What are you guys seeing with agreements for sale? Are you able to assist with agreements for sale?
Yeah. So I'm actually, I do quite a bit of them. I've done a lot in Arizona. As we know, Arizona is one of the best states to do things like that in. But what we're seeing now is laws that have been passed. I don't know if you guys have been aware that the law that was passed in Florida, where they're not doing the land contracts or agreement for sales, and they are seeing different in attorney states and title states. So there's a lot of power in them. In regards to, obviously you need them if you're doing something creative with the VA loan. There's a lot of people with their seller financing. It gives that seller the assurance, that the deed doesn't transfer, but it gives the buyer ownership rights. But on the East Coast, guys, I'm seeing a lot of attorneys not wanting to do them. They don't see it as a closing. The deed does not transfer. So it is a tad bit challenging on the East Coast. I know Florida just passed that law that I'm still reading on so I can become an expert of it. So, but they are great. We use them all the time. We're very fluent on how to use them. There's so many different names, right? People will be like agreements for sale, contract for deed, all these different things. They still have the same characteristics, but we do see them used differently in title states and attorney states.
Rashell, does Constant Close handle subject to transactions?
Oh, absolutely. That's one of our biggest, things that we get from our clients is these sub twos. Yep.
So tell our listeners, what is a subject to transaction?
Oh my goodness, you guys, this is one of the most popular acquisition styles, right? Acquisitions is how you take the property down. So a subject to is basically where you have a seller that has a loan in place with any lender, Chase, Wells Fargo, whatever it might be, and they are going to allow you to make the payments on their underlying lien. So their underlying lien would be the loan that they have with their lender, Chase or Wells Fargo, and the deed will actually transfer into the buyer's name, although the loan will stay in place in the seller's name, which means you are leveraging someone else's credit, but you are actually the owner of the property. So this is a very powerful acquisition strategy, but that's what subject to is where the loan stays in the seller's name, but the deed transfers to the buyer's name and they make the payments on that loan.
So what are the different ways of accomplishing a subject to transaction?
In regards to like taking them down with sellers, or what do you mean?
Well, I think a lot of people hear subject to and think, oh, well, I enter into a purchase contract, I acknowledge the existence of the loans, I close, and then I make the seller's loan payments. But technically, a subject to is one where the loans stay in place, but there could be many ways to structure that transaction. So you could do a wrap agreement. You could do a wrap plus a seller carryback. You could do just, instead of wrapping, and we'll talk about a wrap in a minute, but you could do if the seller wants, equity, they could do a seller carryback and then do what I call a straight subject to, which means you don't wrap the first position loans. You just give the seller a second. You could do a contract for deed, and keep it in place. And then we can even talk about, this isn't really a subject to because the deed doesn't transfer, but we can talk about lease options and keeping the loans in place at that point. But, so
yeah.
Tell us what do you see most as far as your clients and the way they're structuring their subject to transactions?
Yeah. So I would say there's two very popular strategies right now with the way that the market is. So the first one would be a hybrid deal. So a hybrid deal is basically a subject to with the seller finance put together. That's why we call it hybrid. Part of the reason why that's very popular is because of the market that we're in, right? It has to be advantageous for the seller to make that trade to allow you to walk into their property with equity by letting you take over that loan. If a seller is in good standing with their loan and they have this equity and the market is the way that it is, they're just not going to give you their property. They're going to say, listen, my loan balance is $250,000. I know I could sell it for $400,000. I don't want to do the rehab. So I need you to tap into that equity. So that's when I would come in and offer a hybrid deal. And that's a very popular one. But I would say another very popular one is just a straight subject to. Due to COVID over the last couple of years, there are people that are in distress where we can really provide them value in regards to an example like this. So we have a seller that unfortunately lost their job. There could be death. There could be a lot of different reasons of things that had happened, and they're behind on their mortgage and they're going to foreclosure. So we can come and offer them a solution as an investor and say, listen, you're $15,000 behind. This is what subject to is. We could do the trade where you allow me to have the property and pay on your loan, which would do what for the seller? And get their credit where it needs to be, get them in good standing with the lender, improve their credit over time, and give them a solution. Maybe that's a couple $1,000s to get into a rental and be able to start on a good path instead of losing their property. And the best scenario would, what if we could keep them in it and they could rent it, all the different things. So I would say those are the most powerful strategies right now, is a helping people that are in COVID in the foreclosure status and being able to get their credit right, do a straight subject to, and then due to the market and how crazy it is, the hybrid has been very popular. So those are the two that we see quite often.
What documents would a buyer need to accomplish a straight subject to transaction?
Yeah, so I feel like a straight subject to transaction is imperative for you guys to hire an attorney, like Sean has done with the documents that I've had, is have the right disclosures in it. And cut me off, Sean, if I get into the weeds, because this is something that I feel very passionate about. Subject twos, you guys, it is one of my favorite acquisition strategies, but there are risks. There definitely are risks, and I feel like it's my responsibility to say that. And let's talk about a couple of those risks and what needs to be in the contract. The most common one is the due on sale clause. We know that it's very uncommon for it to be called, but if you look at our market the way that it is and the way that it was in the 70s and 80s, there are some similarities. We need to always play devil's advocate to make sure that our financial environment and portfolio is what we as investors can handle. So the due on sale clause needs to be in your contract. It needs to be disclosed to the seller. It is something that a lot of times they are unaware of. Us being professionals in the industry, we need to disclose that, in addition to what's going on with the insurance, right? What's going on with, the payments, how are they made? So you need to invest in your business and hire an attorney to make sure that all of those disclosures are there, and that you actually have documentation disclosures that say, I, the seller, was talked about the due on sale clause. I, the seller, was educated about the insurance. I, the seller, understand that they are leveraging my credit. I, the seller, understand what happens if they don't make a payment. So we could go into so many different things. The main thing that everybody talks about is the due on sale clause, but you need to make sure that, like I said, you invest in your business, hire someone to add all of those disclosures. And you, Sean, know why that's so important, right? Yeah. It's so important. And you want to make those contracts as short as possible. And I know you've heard from us investors annoying you, Sean, and saying, let's make it. But you guys, you know what? Do it the right way. You do it the right way, regardless of the length of the contract, and get better at your sales skills to be able to articulate that to a seller. And that way, if, like I said, you get before a judge or something like that happens, you can say, listen, here's my packet and here's everything that I disclose. And like I said, always playing devil's advocate, but you definitely need those in paperwork.
Now, I use the term wrap.
Yeah.
What is a wrap agreement, and how does that work with a subject to transaction?
Yeah, wraps are very powerful. This is probably like my favorite way to invest. So wraps are basically, let's talk about, you're taking down a subject to, right? If you're taking down, let's say, just a traditional subject to, you're taking over that loan balance wherever it's at. Now, what happens is you can wrap that loan balance. So I always like to look at it as a wrap, right? If you're just thinking about it, if you're visual like me, kind of like a hug, and you're going to wrap it at a higher purchase price and a higher interest rate. And you're probably thinking, why would you do that? And who would want to buy a property like that? Well, there's a lot of people out there. Let's talk about the homestead buyers. Homestead buyers are people that cannot qualify for traditional credit, or maybe they've had an issue with their credit from divorce or whatever it might be, but they have the funds for the 20% down payment. They want to be homeowners. They want home ownership, and they know that they cannot qualify with Chase or Wells Fargo. So they are okay paying the higher interest rate. They are okay with a higher purchase price because they want to be homeowners. And that allows them to get into a place where they could possibly, let's say, refinance it out. So the wrap is going to be an actual, let's talk about Arizona, a note and a deed of trust that go together with the wrap terms. For example, let's say the underlining sub-2 mortgage was $250. Let's say we wrapped it at $280. let's say the 250 interest rate was at 3.5 and we wrapped it at, let's say, 6%. And there would be a gap in that cash flow. So the power for the investors is they've wrapped it at a higher purchase price, a higher interest rate. They have secured their intention of making sure that they get paid with that note and deed of trust that gets recorded with the county at the closing, that ensures that they get paid and they make that cash flow. So God forbid something happens to the homestead buyer, you are able to foreclose on them in that way. So there's going to be your sub-2 contract, your note and deed of trust, and then all of your like closing documentation for your sub-2. So that's kind of what a wrap would look like if you wrapped a sub-2.
Right. So the original loan stays in place, and let's say the original loan is 200,000. The seller may say, "Well, I'll at let's just say 4% interest. I'll do this transaction, but I want a loan for 200,000 at 6% interest. So I want a 2% spread there. And oh, by the way, um, if you can set it up two ways. One, you could have the buyer paying monthly on the original loan, or you can have like a servicing agent and they pay, and then the servicing agent pays on the loan. But basically, you're saying, hey, look, if buyer, you fail to make the loan payments that I am otherwise required to make under my loan, I've wrapped it with my own loan, and therefore I can foreclose. I can step in, I can start paying that original loan back, and then I can foreclose. I'm a lender at that point. I'm a second position lender on the property. Now, you mentioned a note and deed of trust. Do the title companies normally prepare those documents, or where do you find those?
Yeah, they should. All title companies, I get this question all the time, have a board of directors, usually attorneys, right? Or access to an attorney, and they should be proficient in being able to do that. But at Constant Close, we can handle those note and deed of trust that might look different in another state. I always get that question. It might be a mortgage and a promissory note, but we can come in and assist, because we do have some newer places where these deals are not known of for, been done for a long time. So we can assist and write those if they're not able to. But absolutely, your attorney and your title partner should be proficient in being able to write these. And that goes back to our first question of vetting them in the beginning. And if they don't do that, then you hire an expert like myself, or you switch to another title company, or you could even hire an attorney. You could definitely do that too, and hire an attorney to write that up for you.
So I was at a marketing event last night, and a couple of the speakers, mentioned the fact that Arizona is one of the most competitive markets for, real estate investing, and what they called the land of gurus. So it's real easy here to find, an attorney that can help with this, these types of transactions, and even title companies. They're all out there, sponsoring events, trying to, garner the business of the real estate investor. And so they become proficient in it. But I'm called regularly, asking, hey, Sean, I'm doing this transaction in some other state. I have no clue where to begin. And I know that you and I have kind of collaborated in the past of trying to help people, connect with attorneys and title companies in other states. Tell us about the ability of Constant Close to, assist their clients with access to, or accessing or finding attorneys and closing attorneys or title companies in other states.
Yeah, so this is something that we actively do. Our TCs do, is we have our partner list, right? We have our partner list that we vet. So vetting looks like, submitting all of our documentation. We're able to do that because, once again, back to my first point, is time is of the essence with these deals, right? You want to get escrow opened, you want to get things moving along. So we have our title and attorney partners in all 50 states. Very happy to share those things. But as you know, there are some attorneys or title companies that don't want to take any more business, or want to work with someone that can help them navigate the transaction because we have a relationship with them. So when you're working with us, it's not something you have to worry about. You say, hey, Rashell, I'm virtually investing in Alabama, and I got a new contract. what do? You submit that contract to us, we open it up with our partners, and we start navigating that transaction. So that's how we can kind of provide that value of, you guys don't have to think about it. Let us handle it and we'll take care of it. Yeah.
Rashell, I have a follow-up question about the due on sale clause.
Yeah.
In your experience, what are you finding after disclosure of the risks of the due on sale clause? Are you seeing basically everybody just accepting that risk and moving on, or is that blowing up deals?
Um, I would say there's not a lot, but I feel like there are some transactions coming around where it is blowing up the deal even after close of escrow, even if the disclosure was given to them. And the reason for that being is there's additional risks besides the due on sale clause. We have the seller risk. It's not the nature of the seller to remember that they sold you their home subject to. If you don't know how to do these types of transactions and you don't hire an expert and handle that communication, the lender could call the seller and the seller says, you know what, I sold my home to Rashell 2 years ago. They don't remember these things. So there's seller risk. And once again, if you don't handle the insurance the right way, there's another risk. So back to the point of hiring an expert, but I am seeing some of these deals blowing up after close of escrow because it wasn't navigated the right way. And that's the important part of it, is making sure, like to your guys' questions, what you need in there and all of the different disclosures. So I do see that happening, with some people that just unfortunately haven't done it the right way. And I would say that'd be after close of escrow. So I think generally during the transaction, everybody's bought into it. Everybody's okay with it, but it's just not navigating it the right way after close of escrow. And unfortunately, I've seen those things because creative finance attracts a crowd, right? No credit, no cash, no credentials. And it's a big mass of people that it'll attract. So this is why it's imperative to, like what you guys are doing, getting out there and showing people, hey, do it the right way. So, but I have seen it before, and a little bit more common these days.
Rashell, does Constant Close assist with lease options?
Yeah, absolutely. Yep.
Why would an investor want to do, say, a lease option over a subject to transaction?
Well, lease options allow you as an investor to gain that capital. So what does that mean? A lease option is kind of like a rent to own. Just a lot of people know that terminology a little bit better. So you're giving someone an option to buy the property at a certain price at a future date. Now, what happens is they pay for that option. So that option could be anywhere from, I've seen like $5,000 to $15,000, $20,000 that's paid up front and generally non-refundable. So like I said, that allows the investor to gain that capital. And unfortunately, a lot of people don't extend their option. They don't really extend it. So what happens at that point in time? They're not going to buy the property. So you get another lease option tenant in there. And once again, you gain that capital and you give them the option to buy the property at a future date for a certain price. So it's all depending upon where you're at as an investor. Do I need capital? Does this make sense? Diversification. And that's probably the reason why people like lease options, is because generally they don't, take their option and they're able to get that capital up front. So that's probably one of the reasons why investors like to go with lease options.
Have you seen any of your investor clients actually doing acquisitions of properties via lease options? Meaning,
Yes.
you can dispose of the property by lease option, and gain that capital. But, as an investor, I go in and say, I don't want to do a subject to a wrap or anything like that. I just want to enter into a lease, pay you for an option, and then have the ability to, purchase the property later on. Have you seen your investors, wanting to do that? And do you assist them with that?
Yeah, we do assist them with that. I wouldn't say it's as common as what we were just talking about, but yeah, there are some investors that do that, but just not as common as taking it down like subject to and then lease optioning it. But yeah, we do that. We have a documentation. So people would say, what is that documentation like? You have to have a lease agreement and an option agreement, right? That dictates, once again, being very clear and transparent. What is that option fee? Disclosing that it's non-refundable. Make sure you have that in there. And what does that lease look like? And what's the price? And what are all the different terms in it? So, but yeah, I've seen them do that on the acquisition side.
Now, another important provision in a lease like that would be that you have the ability to sublet, right? Because you want to, chances are you're not going to be leasing it as an investor. So you want to be able to sublet. Have you seen, and I've always been curious about this type of transaction. Have you seen where they've done a lease with an option and then either assigned the option or entered into a sublease with a second option, meaning I'm going to buy it for this amount, but I'm going to give you the option to buy it from me if I exercise my option for this amount. Have you seen that type of, basically double lease, double option type arrangement?
Yeah, it's actually getting very, very popular. And the reason for that being is they're able to make that cash flow on it without actually owning the property. And so I've seen this done in apartment complexes. I've seen this with just traditional single family. So why would somebody want to do that? It's because you don't have to take the property down. So you have an owner that you can say, listen, I want to be able to lease your property and manage that and get a sublease on it. So you have the lease agreement with the seller, and then you go and you sublease it with the permission, and you're able to increase those rates and make that, cash flow on it. So it's actually, I would say this year, I've seen more of those than I've ever seen, but they're getting very, very popular.
So in all the transactions that you work on, whether wholesale, novations, creative financing, et cetera, what are the top 3 reasons that you find that a transaction falls apart?
Yes, I would say one of the reasons is your partners, right? Your title and attorney partners. Sometimes you have sellers that are not wanting to extend the close of escrow rated den because you didn't do what you needed to in the beginning. And I would say if you're new to the industry, the second reason would be team up with somebody, JV with someone, hire an expert, be able to not be greedy about one deal and invest in your business and hire someone or JV with someone that knows what they're doing. Back to my theme, I guess, it's imperative that you learn to do it the right way. And I would say the third thing is making sure that once again you have all the right documentation, because a lot of people are just very concerned in the transaction taking down the property. There are things that can happen after close of escrow that a lot of people don't think about because they're so excited that they took down the property. They're so excited they're adding to their portfolio. So think about the future. Is your business set up the right way? Is your paperwork, is the transaction set up the right way that you can close on this property and sleep good at night, instead of having these issues, year 1, year 2 after you've closed on the property. So I would say those 3 things are the biggest things that I see that I hope investors will pay a little bit more attention to.
Rashell, as self-evident as I think the answer is to this question, given our almost hour here with you, why do you think investors should use a transaction coordinator?
When you want to have a successful business, there are people, the who's in your business that you need to have a successful business to scale. Whether that be 3 to 5 deals a month or scaling to be doing like a 7-8 figure type of company. One of those imperative, important people is the transaction coordinator. They're behind the scenes. And they are the people that kind of run the business. Now, why? It's because they touch everybody on the team. They're there with the acquisitions. They're there with the dispositions. They're there with managing the team. And what a lot of people don't talk about, the transaction coordinator, if you hire the right person, can help you scale your business. Why? Not only are they touching the team, they're talking to your sellers, they're talking to your title and attorney partners, they're talking to your buyers. And this is a people business. They touch all of those different people and points that if you put the right person in the place, they are going to want to do business with you because of that person that is kind of the face of the team. So it's very important if you want to scale or have a successful business to have a TC in there. And also, like I said, they are the face of the company. And I don't think a lot of people realize that. So you need a transaction coordinator.
So where can people find you? Where can people find Constant Close?
So you can go to our website at constantclose.com. We're on IG also, just at Constant Close. So you can look us up on Instagram. You can message and get on our website. We do have a Facebook group that we have also. It's Creative Real Estate with Constant Close, where we do things like this just to give value back and to help people understand how to navigate these transactions. So we are just our name. You can find us pretty much anywhere, and you can get in contact with us there.
Rashell, we really appreciate your time being here with us on the program. For our listeners, find Rashell Jarvis, Constant Close. Thanks so much for being with us.
Awesome. Thanks for having me. I appreciate it.
Thank you, Rashell.
See you next time.
Bye.
All right, everybody. That is our show for today. A couple quick comments. Next week's episode, leads from probate attorneys, the investor's guide to probate leads. Make sure to join us for that. We'll be live next Tuesday, same time, same place. We'll see you next week.
Have a good day, everyone.